I've got three short slides for you on this, but I'm going to give you the conclusion now. In fact, I'm going to give you a prologue to the conclusion before I give you the conclusion. The prologue to the conclusion is that in terms of Mexico and doing business there, more than maybe a lot of other countries, it's a very human country, and the commercial relationships that you form and strike there will help you not just to avoid disputes, but ideally to resolve them before you have to sort of lean back on the hard stuff. But in terms of the hard stuff, when the rubber hits the road and you find yourself in a formal dispute, the key point, the conclusion here is control the things that you can control. And resolution of disputes and the applicable law and the method by which your dispute is resolved is one of those things that you can control in advance. And a little bit of attention, like so much of what Enrique has been telling us earlier today, a little bit of attention at the outset when you're entering into contract can save a huge amount of trouble later on. And I'm going to give a solution at the end, but before we get to the conclusion, I just want to take a few moments, first of all, to say a little bit about the Mexican system and what the options available are. First of all, as many of you know, Mexico is a civil law jurisdiction. In, I'm afraid, very simplistic terms, that means they don't have the sort of case law of reliance on precedent that we have in this country. Their laws are codified in civil codes and they are interpreted by the judges broadly on a case-by-case basis, which gives the judges in any particular case a certain degree of discretion, and you can have situations where different judges are applying things in different ways. The court system itself, if you think about the practicalities, unless you're a fluent Spanish speaker and unless all of your documents are already in Spanish, there's going to be a lot of time and cost and trouble in terms of interpreters, just as a matter of practical matters. Also, as a matter of practical matters, the truth is, I think it's fair to say, that the Mexican courts don't have a lot of experience dealing with the sort of oil and gas disputes that many of you are familiar with. But the good news, if you like, is that Mexico is very sophisticated in terms of recognizing party autonomy. In fact, ADR, alternative dispute resolution, is positively promoted. And so there are opportunities to decide what law you want to govern your contract, and also in the event of dispute, how you want that dispute to be resolved. There are some maybe practical limitations. There are specific areas which are reserved for Mexican law and Mexican courts or tribunals, the sort of things you'd expect: tax, IP to a certain extent, labor issues and all the rest of it. But if we're talking about your typical commercial dispute, you have great discretion to decide, for example, to have the law of England or Wales, the law of New York, or some other place apply to that contract. There's, I suppose, some practical nuance that if you're contracting with Pemex, they will typically expect Mexican law to be used, but they will not infrequently be very happy to enter into contracts where the ICC is the body that deals with the dispute resolution. And ultimately, that's where I'm going at the end of my proposed solution, an arbitration solution. Briefly, before moving on, performance and payment security, that can be a very practical concern. And again, there are maybe a slight simplification, but no real restrictions under Mexican law in terms of the types of security, standby letters of credit, all that sort of thing that you can put in place, and in terms of enforceability. That's not necessarily the case all over the world. So, moving along, in terms of the key issues that you would be thinking about when you're preparing to come to a landing on governing law and dispute resolution clauses, it's helpful to have, I think, three key points in mind. First of all, enforce. There's no point getting a great judgment or award if there's no prospect of successfully enforcing it against assets of the counterparty. Secondly, getting the right result. There's no point being able to enforce an award or judgment if you don't actually get there. And then finally, time and money, which of course is what your CEO and your CFO will be interested in. How quickly can I get the result, and how much will it cost me to get there? And just to unpack each of those very briefly, as I've mentioned earlier, in terms of recognising party autonomy, Mexico is a pretty liberal regime, and there's really no reason why you can't put the sort of adequate measures in place that you'd like to put wherever around the world you might be doing business in place to protect yourself. If you have to enforce it in Mexico against a company in Mexico, Mexico is a signatory to the New York Convention, which means it will recognise arbitration awards, and they can be taken to courts in Mexico and enforced there. That's actually a more efficient process than, for example, trying to take an English court judgment over to Mexico. That can be done, but you will be better off with an arbitration award. So that's another plug, if you like, in favour of arbitration. One of the other points about arbitration, and this is beginning to sound more and more like a plug for arbitration, in terms of getting the right result. One of the features of arbitration, of course, is that generally speaking, the parties are free to choose the composition of the arbitral tribunal. So you may choose an arbitrator, your counterparty chooses one, and together they choose a third, and those three arbitrators will decide. That allows you some control over the integrity of the process, and also, I mentioned earlier, in some of these sorts of disputes, it's really very important to have people who have that industry background and understand what you're talking about in order to get the outcome that is the right outcome. And finally, time and money. I think you'll hear a lot of people say that this is where arbitration sometimes falls flat on its face. I have taken sympathy with that, particularly if you're talking about some of the big arbitral institutions. It can be time consuming and take longer than it should. A lot of these institutions are very aware of that, and they've been trying to take steps to improve the position. But if you have the opportunity, the top tip, in my view, is to try and agree that any disputes will be resolved by, ideally, a single arbitrator chosen from a pre-selected panel. You can actually name them in your contract. One of the things we've discovered, particularly in some of our biggest disputes where we've had very grand people acting as arbitrators, it's very difficult for them to find time in their diary to respond to things and move things along, to get all three of them together. So if you can condense that sort of process down, it all has to be done at the front end when you're agreeing that contract. It's a small point, but later in the day, if you have a big issue, a big dispute, you may be very thankful for it. So thank you very much. That's all I have to say about dispute resolution. Enrique, would you like to?